11 a.m. I call the meeting to order and respectfully request that we all stand for the national anthem. Thank you very much. Distinguished ladies and gentlemen, it is with great pleasure that I welcome you all to the court-ordered meeting of our company, Consolidated Hallmark Insurance, PLC. The quorum required by Article 8.6 of the company's Articles of Association is 2 or more members holding not less than 25% of the paid-up capital of the company. The company secretary has advised me that a quorum has been formed. The meeting is therefore properly constituted, and accordingly, I hereby declare the commencement of the meeting. Before proceeding to the formal aspect of this meeting, introducing the members of the board of your company, I wish to convey the apologies of the following directors who are unavoidably absent. As you know, I am Mr. Obinna Kezie, chairman of your company. Thank you. The other directors of the company here present will now be introduced.
My name is Edi Efekwa, the managing director of Session.
My name is Bola Otukale, non-executive director.
Good morning all. My name is Babatunde Daramola. I'm the executive director of Finance and Investments.
My name is Ruka Efala, I'm the company secretary.
My name is Shuaibu Idris, MNI, independent non-executive director.
Good morning. Raju, Executive Director Operations.
I am Prince Ben Honora, Non-Executive Director. Thank you.
Dr. Lai Fatino, Non-Executive Director, is on his way. He'll be here shortly. Furthermore, I would also like to introduce the respective professional parties who are advising us on this scheme of arrangement and assisting our company in taking the various steps necessary to conclude the scheme. Chapel Hill Denham Advisory Limited, Financial Advisor, Kemi Awodeyin. Alliance Law Firm, Solicitor, Albert Adu. Planet Capital Limited, Stockbroker, Emeka Anonya. Meristem Registrars and Probate Services Limited. Registrar Sheyi Owoturo. BBC Professional Services. Fairness Opinion Advisor Olani Abeje. PKF Services. Tax Advisor Busayo Olawole. Our auditors, SIAO partners, will be acting as scrutineers at this meeting. Before I go on, Dr. Olai Fatima just arrived. Welcome, Doc. Thank you. I would also like to introduce the representatives of the regulators who are here to witness the proceedings of this meeting. Regulator, Securities and Exchange Commission, Mr. Abu Ibrahim. Thank you. Nigerian Exchange Limited, Mr. Olorotimi Kuti, joining virtually. National Insurance Commission, Mr. Bankole Ajibola. From National Insurance Commission, who is from NICOM? Okay. Ben.
Rabi Abdulaziz Dankano.
Okay. Central Bank of Nigeria, Mrs. Grace Oluwadamilare and Mrs. Cecilia Wosu. Thank you. National Health Insurance Authority, Mr. Chinyere Onwohiri. Sorry, Mrs. Chinyere Onwohiri. I'm Igbo too. I was wondering why is it Chinyere. So I didn't know what. I was confused. I was confused. Why is it? So it was a typo. I will now call on the company secretary to read the notice convening this meeting.
Thank you, Mr. Chairman. Good morning, distinguished shareholders. Notice of court-ordered meeting in the Federal High Court holding at Lagos, Nigeria, in suit number FHC LCS 1801-2022, in the matter of the Companies and Allied Matters Act 2020, and in the matter of an application under Section 715 thereof, and in the matter of Consolidated Hallmark Insurance PLC with ROC number 168762, and the holders of his fully paid ordinary shares. Meeting of the holders of the fully paid ordinary shares of Consolidated Hallmark Insurance PLC. Notice is hereby given that by an order of the Federal High Court, hereinafter referred to as the Court, dated October 13, 2022, made in the above matter, the Court has directed that a meeting, also known as the court-ordered meeting or the Court, of the holders of the fully paid ordinary shares of Consolidated Hallmark Insurance PLC, that is the company, be convened for the purpose of considering and, if thought fit, approving with or without modification a scheme of arrangement known as the scheme pursuant to Section 715 of the Companies and Allied Matters Act 2020 between the company and the holders of the fully paid ordinary shares of 50 kobo each in the company. The meeting will be held on Tuesday, November 1st, 2022 at Radisson Blue Hotel, 38 and 40 Isaac John Street, GRA, Ikeja, Lagos, at 11 a.m. or soon thereafter, at which place and time shareholders are requested to attend. copies of the scheme document containing details of the scheme have been made available to shareholders of the company. At the meeting, the following subjoined resolution will be proposed, and if thought fit, pass as a special resolution of the company. That one, the scheme of arrangements dated October 13, 2022, a printed copy of which has been produced for the meeting and for the purpose of identification only, signed by the chairman, be and is hereby approved. 2. In accordance with the scheme of arrangements, the 10,840,000,000 ordinary shares of 50 kobo each in the issued and paid up share capital of the company and held by the shareholders be and are hereby transferred to Consolidated Hallmark Holdings PLC, also known as the Holdco, in exchange for the allotment of 10,840,000,000 ordinary shares of 50 kobo each in the share capital of the Holdco to the shareholders in proportion to their shareholding in the company, and to be credited as fully paid without any further act or deed. 3. The board of directors of the company be and is hereby authorized to take all necessary action to delist the shares of the company from the official list of the Nigerian Exchange Limited, following which the company will be re-registered as a private company. 4. The memorandum and articles of the company be and are hereby amended as set out in the annexure to this notice. And 5. The board of directors of the company be and is hereby authorized to do all such things and take all such actions as are required to give effect to the scheme, including consenting to any modifications of the scheme of arrangement or any condition that Securities and Exchange Commission, the National Insurance Commission, the Federal High Court, or any other regulatory authority may think fit to approve or impose. The said scheme will be subject to the subsequent sanction of the court and delivery of a certified true copy of the order of the court sanctioning the scheme to the Corporate Affairs Commission. Thank you.
Proxies and voting. Please be informed that the company has received proxy forms from some shareholders in respect of this meeting. Please note that voting on the resolutions to be moved at this meeting will be by way of poll, which means that every shareholder present in person or by proxy shall be entitled to one vote for every share they hold. Court order. Distinguished ladies and gentlemen, this meeting has been convened pursuant to an order of the Federal High Court of Nigeria holding at Lagos with regard to the proposed scheme dated 13th day of October 2022 between the company and the holders of its fully paid ordinary shares. I will now call on the representative of the solicitors of the company, Alliance Law Firm, to read the court order directing that this meeting be convened.
Mr. Chairman, sir, directors, and dear shareholders. In the Federal High Court of Nigeria, in the Lagos Judicial Division, holding at Lagos, suit number FHC LCS 1801-2022. In the matter of an application under Section 715 of the Companies and Allied Matters Act 2020, and in the matter of Consolidated Hallmark Insurance PLC, in re Consolidated Hallmark Insurance PLC, applicant. Order. Upon the originating summons dated and filed on the 21st day of September 2022, coming up before this honorable court and praying for the following reliefs. 1. An order directing the applicant to convene a meeting of the holders of the fully paid ordinary shares of the applicant for the purpose of considering and, if thought fit, approving with or without modification the scheme of arrangement between the applicant and the holders of its fully paid ordinary shares in the form and context specified in the scheme of arrangement annexed herewith or subject to such modification, additions, or conditions agreed between the applicant and the holders of their fully paid ordinary shares and or approved or imposed by this honorable court. Two, an order directing that the said meeting of the applicant be convened and held in Lagos on the 24th day of October 2022 or such other date as the applicant's board of directors may deem appropriate at 10 a.m. or soon thereafter. 3. An order in the notice of such meeting, the scheme, and the explanatory statement be sent to the email addresses of the shareholders appearing in the register of members of the applicant. 4. An order that the meeting be held and concluded in the manner that general meetings of the applicant are held and in accordance with the provisions of the applicant's articles of association, save that A. Voting at the meeting shall be by poll, and each shareholder shall be entitled to 1 vote for each share they hold in the applicants. B. Only persons indicated as selected proxies in the notice of the meeting would be able to attend the meeting and vote on behalf of themselves and the shareholders of the applicants who selected them as proxies. Other shareholders of the applicant will be able to join the meeting and follow the proceedings online via the real-time streaming options. And C, the statutory threshold required to pass the resolutions at the court-ordered meeting is a majority representing not less than 3/4 in value of the ordinary shares of members present and voting in person or by proxy. 5. An order that the meeting shall be convened by a shorter notice period to the shareholders than the statutorily prescribed 21 days, which notice shall be furnished by way of publication in 2 national daily newspapers. 6. An order directing that if the meeting of the members of the applicant agree to and approve the scheme, a report of the court-ordered meeting be presented to this honorable court for sanction of the said scheme. 7. And such further order or orders as the honorable court may deem fit to make in the circumstances. Upon reading through the said summons, its supporting affidavit of 18 paragraphs, 5 paragraphs affidavits of non-multiplicity of action, both deposed to by Rukowe Falano, female, Christian, Nigerian, an employee of Consolidated Hallmark Insurance PLC of number 266 Ikorodu Road, Obanikoro, Lagos State, with exhibits marks CHI-A through CHI-E attached thereto and written address signed by Uchechukwu V. Obi S.A.N., counsel to the applicant, and filed at the Federal High Court Registry, Ikoyi, Lagos, on the 21st day of September 2022. after hearing Theophilus Ochonogo Esquire with Samuel Ugu Esquire, counsel to the applicant, move in terms of the motion paper, and having carefully considered the application and submission of counsel, it is hereby ordered as follows. 1. An order is hereby made directing the applicant to convene a meeting of the holders of the fully paid ordinary shares of the applicant for the purpose of considering, and if thought fit, approving with or without modification, the scheme of arrangement between the applicant and the holders of its fully paid ordinary shares in the form and context specified in the scheme of arrangement annexed to the summons, or subject to such modification, additions, or conditions agreed between the applicant and the holders of their fully paid ordinary shares. 2. An order is hereby made directing that the said meeting of the applicant be convened and held in Lagos on the 24th day of October 2022, or such other date as the applicant's board of directors may deem appropriate at 10 a.m. or soon thereafter. 3. An order is hereby made directing that a copy of the scheme document incorporating the notice of such meeting, the scheme, and the explanatory statement be sent to the email addresses of the shareholders appearing in the register of members of the applicant. 4. An order is hereby made that this meeting be held and concluded in the manner that general meetings of the applicant are held and in accordance with the provisions of the applicant's articles of association, save that A. Voting at the meeting shall be by poll, and each shareholder shall be entitled to 1 vote for each share they hold in the applicant. B. Only persons indicated as selected proxies in the notice of the meeting will be able to attend the meeting and vote on behalf of themselves and the shareholders of the applicant who selected them as proxies. Other shareholders of the applicant will be able to join the meeting and follow the proceedings online via the real-time streaming options. And C. The statutory threshold required to pass the resolutions at the court-ordered meeting is a majority representing not less than 3/4 in value of the ordinary shares of members present and voting in person or by proxy. 5. An order is hereby made that the meeting shall be convened by a shorter notice period to the shareholders than the statutorily prescribed 21 days, which notice shall be furnished by way of publication in 2 national daily newspapers. 6. The court-ordered meeting so held shall approve the scheme, which shall be submitted to this court for necessary sanction on the next adjourned date herein referred to as the return date, fixed against the 9th day of November 2022, issued at Lagos under the hand of the presiding judge and seal of this honorable court this 13th day of October 2022. Signed, Oluwakemi Obalaja, Registrar. Thank you, Mr. Chairman.
Thank you. Distinguished ladies and gentlemen, a copy of the scheme referred to in the court order has been reproduced on pages 20 to 23 of the scheme document which you received prior to this court-ordered meeting. That's it, right? This is it. There's the document. I confirm that the scheme document, together with the proxy forms for use at this meeting, were dispatched to the members of the company, and efforts were made to ensure that all members received and were able to study the document properly before this meeting. Notice of the meeting was also published in 2 national daily newspapers, the Daily Sun and the Punch, on Wednesday, October 19, 2022. The scheme document contains respective information, including the explanatory statement from the financial advisors to the company, specifying the elements, rationale, and the effect of the proposed scheme, the scheme of arrangement, the fairness opinion report, further information on Consolidated Hallmark Insurance PLC, statutory and general information, and a notice of the court-ordered meeting, which, with your permission, will be taken as read. As you would have observed from the notice convening this meeting, the purpose of the meeting is to consider and, if thought fit, approve with or without modification a proposed scheme of arrangement pursuant to Section 715 of the Companies and Allied Matters Act 2020 between the company and the holders. I wish to say a few words on key aspects of the scheme, particularly its envisaged effects. Justification for the board for the proposed scheme of arrangement. The board believes that the scheme will create considerable benefits and opportunities for employees and other stakeholders of the company, including ensuring the business maintains its competitive advantage and financial viability, and positioning the company to take advantage of value accretive opportunities in line with our broader objectives. Effect of the scheme of arrangement. The board considers the scheme of arrangement to be the most appropriate approach to creating greater strategic flexibility and improving returns to shareholders. The scheme of arrangement will result in shareholders receiving shares in the holdco in the same proportion as their current holdings in the company, and the company's shares and those of each subsidiary being held wholly by the holdco. Consolidated Hallmark Holdings PLC, the holdco insurance business, will continue to be subject to NICOM regulations. In addition, the subsidiaries of the holdco will continue to be subject to the oversight of the respective regulatory authorities that supervise their sectors. The group's firm-wide risk management framework will continue to apply across the entire restructured group. The holdco will be a non-operating entity. The board considers the terms of the scheme to be fair, reasonable, and in the best interest of the shareholders, and unanimously recommends that you vote in favor of the subjoined resolution that will be proposed at this court-ordered meeting. It is particularly important that as many votes as possible are cast at the court-ordered meeting to satisfy the court that there was a fair representation of shareholders at the meeting. Questions and answers. Ladies and gentlemen, I will now give you an opportunity for questions and comments on all aspects of the scheme. I will request that reference be made to the page in the scheme document to which your question is related, in order to assist us in giving appropriate responses. Members should kindly ensure that their comments are brief and questions limited to one person, so that other members will have an opportunity to ask questions or make comments. I also request that before asking a question or making a comment, you should kindly state your name. Thank you. Anyone with questions, please, or comments?
Mr. Chairman of the board, today's meeting is one agenda item meeting. I don't think we are going to the profit and loss to discuss other than to see how quickly we can decide on the court-ordered meeting so that the board can proceed. I've gone through the document and I discovered the cleverness of the chairman and his team and the MD and his management team. What we are going to achieve by this, now the outstanding capital is about, let me see, sorry, it's not like before when I can flip through as quickly as possible. I have to take my time now. Yes, the issue ordinary shares outstanding for us now is
Sorry, you didn't introduce yourself, please.
Pardon?
Can you introduce yourself so everyone knows who you are?
I'll do that. My name is Sason Ewosu. I'm a shareholder. Yeah. So, the outstanding on-issue share here is 10,836,000,000 shares outstanding. And cleverly, we are talking about another 4 billion, which will be taken out of that, reducing the pains of trying to meet regulatory requirement, which says any on-issue share by December 31st will either be cancelled and we will also be penalized. So with this scheme, we've actually gone through that, and there is no way they can penalize us, because what we are taking from that will further reduce whatever is left. So by my understanding very clearly, what we are talking today is creating a HOCO company, which is a group company. Also, it is wrong for us to say that the group itself will not be effective, will not be working, because it's coordinating other companies under the group, including the health and all this and that. So it's a right direction that we have taken to do this today. And of course, we have no two ways to it. When we approve this, everybody will now have shares in the group. So we are just going to be moved straight. Whatever we are having in the company will become a group holding. So what I'm saying very clearly is that let's follow the timetable which you have given to us here. As to there's a timetable on this scheme of arrangement, which shows us how we are going to move to get approval from Almighty NICOM and the Security and Exchange Commission. Of course, the stock exchange is a trouble spot now. They have no choice. They quickly give an approval. Otherwise, many companies want to delist because of the trouble there. There's a serious problem. I've always been saying it, that most of the regulators may not be good managers managing institutions. That's exactly what has happened in the stock exchange. They were regulating us before. They were any little infraction, they issue penalty. Now look at it. Look at what. That's why you and your team must be very careful. Don't give them room to penalize us, because that penalty should be kept for us for dividend. I was actually worried when I look at the size of the capital base. I was worried about paying tangible dividend to shareholders. But once the first tranche of 4 billion is off from it, it makes it slimmer a little bit, so that dividends should be robust for those that have invested in any company. We're not saying you as directors should not take care of yourselves. Take care of yourself, but remember the ordinary shareholders. It's very, very important. So I do not know the line to take other than we need to move a motion accepting this thing. It's in perfect order as far as I'm concerned. You've done very well about it. We are not losing anything, neither you losing anything. Rather, you are increasing our opportunity of going home with a good dividend. So I appreciate it. On behalf of other shareholders who are not here, whom I am representing, I will go for this. I will go for this, because that is what the court wants, for us to approve it. You know, sometimes I said, it's Superman, say nothing be wayo, na sense past sense. So this is part of it. Eddie, I'm not referring to you. You know. So if Nigeria knows the way of its Superman, we won't be into the problems we are today in Nigeria. So, Mr. Chairman, that's my opinion.
Thank you very much, Sir Sonny also.
So you need to move and get a support for.
Can I just ask if there are any other questions?
Yeah, you are free. Yeah, you are
please.
chairman.
Do you have any other questions or comments? All right. So we can move. Yeah. Ladies and gentlemen, we have come to the point in the meeting where the subjoined special resolution is to be tabled for your approval. Voting on the resolutions will be by poll, which means that every shareholder present in person or by proxy shall be entitled to one vote for every share that he or she holds. The statutory majority required to approve the scheme is a majority representing not less than 3/4 in value of the shares of members present and voting either in person or by proxy at this meeting. I confirm that a number of shareholders have sent in proxy forms indicating how their votes should be cast. On your arrival at this meeting, the registrars confirm the number of shares you hold in the company. This information has been configured on the voting device assigned to you. The registrars will give the requisite voting instructions. Please press the appropriate buttons as explained by registrars, depending on whether the vote is in favor of the resolution being considered or against the resolution being considered. And I'll call on the company secretary to read the subjoined special resolution that is to be considered.
Thank you, Mr. Chairman. The special subjoined resolution to be considered is in the notice of the meeting on pages 48 and 50 of the scheme document, and it states, 1. The scheme of arrangement dated October 13, 2022, a printed copy of which has been produced for the meeting, be and is hereby approved. 2. In accordance with the scheme of arrangement, the 10,840,000,000 ordinary shares of 50 kobo each in the issued and paid up share capital of the company and held by the shareholders be and are hereby transferred to Consolidated Hallmark Holdings PLC, the holdco, in exchange for the allotment of 10,840,000,000 ordinary shares of 50 kobo each in the share capital of the holdco to the shareholders in proportion to their shareholding in the company and to be credited as fully paid without any further act or deed. 3. The board of directors of the company be and is hereby authorized to take all necessary action to delist the shares of the company from the official list of the Nigerian Exchange Limited, following which the company will be registered as a private company. 4. The memorandum and articles of the company be and are hereby amended as set out in the annexure to this notice. And 5. The board of directors of the company be and is hereby authorized to do all such things and take all such actions as are required to give effect to the scheme, including consenting to any modifications of the scheme of arrangement or any conditions that Securities and Exchange Commission, the National Insurance Commission, the Federal High Court, or any other regulatory authority may think fit to approve or impose. Thank you, Mr. Chair.
Thank you. Before I propose the motion, the registrars will provide us with instructions on the use of the voting device.
Where the secretary said that the company will be delisted from the official list, following which the company will be re-registered as a private company. So please, can you clarify that aspect?
So I'm assuming
that's item 3.
So consider Hallmark Insurance PLC, which is the insurance company now, which is the listed entity on the Nigerian Stock Exchange, will be delisted.
Yes.
And now the holdco, consider Hallmark Insurance Holdings, will now be the entity listed in the stock exchange.
Okay, thank you. Because we are shareholders, when you start talking about private company,
yes,
we exercise some fear about that.
No problem.
It's clearer now.
Thank you very much. Please go ahead.
Thank you, Mr. Chairman.
We have the voting device before us. The first button is 1A, and the second button you have there is 2B. You are pressing 1A if you are voting for the resolution, and you press 2B if you are against the resolution. Are we clear? Okay. 1A is if you are voting for the resolution. 2B if you are voting against, as it is displayed on the screen right now. You have 1 for and 2 against. Please, I will guide you on the voting. When we say vote, that is when you press either 1 or 2, depending on what your option is. Thank you, Mr. Chairman. Okay, thank you. For this meeting, we received 295 shareholders voting in person and by proxy with a shareholding of 8,849,257,165 units of Consolidated Hallmark Insurance PLC shares, which represents 81.64% of the total shareholding of the company. Thank you. Yes. Okay, sorry about that. So we have a quorum to vote. So back to you, Mr. Chairman.
Thank you. I hereby propose that the resolution just read by the company secretary and stated in the notice on pages 48 to 50 of the scheme document be approved. Would someone please rise to second the motion?
Sorry, I will sit down to second the motion, not
Okay.
rising.
Sorry.
Yeah.
Okay, thank you very much. Sir Sonny also is seconding the motion. Thank you. I'll now put the motion to the meeting for the vote and ask registrars to conduct the voting process.
Thank you, Mr. Chairman. Please, can we have the display? For the resolution being considered, we have the poll open. Please vote now. Press 1 if you are voting for the resolution, and 2 if you are voting against. The poll is still open and is displayed. Have we all voted? Okay. We are counting down. We have the result. So for the resolution being considered, we have 295 shareholders voting in person and by proxy, holding 8,849,257,165 units of Consolidated Hallmark Insurance PLC. The resolution received 100% vote. There is no vote against, and there is no abstention. Thank you.
No. Okay. I therefore declare the special resolutions approving the scheme carried. Closing remarks. Ladies and gentlemen, the announcement of the results has brought us to the conclusion of the business of the court-ordered meeting. The report on the outcome of this meeting will be filed with the Securities and Exchange Commission and Nigerian Exchange Limited, and subsequently the Federal High Court for a sanctioning of the scheme, following which the scheme will become effective. On behalf of the Board of Directors, I thank you all for taking the time to attend this meeting. Please rise for the national anthem.